So welcome back to our final session of the day. The first thing I'm going to say is that I promised we will finish on time. So don't start, slipping off just in case we're going to run over. We are definitely going to finish on time, and we will actually finish a little bit early. I'm Maria Lee from UCL, and I'm stepping in for Eloise, who, as you saw earlier, is in Australia. I hope she's asleep at the moment, but if she isn't, we are missing you, Eloise. But it's going really well. You can be really pleased with the way it's going, I think. Okay, so in this session, we are looking at international law, international processes, and COP26. So perhaps a little belatedly, but that's about having a conference in multiple time zones. Perhaps a little belatedly, we're going to look at the role of international institutions in this question of rule of law and climate change. We have three really great speakers. I'm really looking forward to this. We're going to start with Christoph Schwartz, who's here in the room with us. He's Executive Director at Legal Response Initiative, which is a wonderful organisation providing legal advice to support poor and climate vulnerable developing countries and civil society organisations in the climate negotiations, which we know are complex, technical, legal moments in the climate change journey. And he was formerly a member, he was a member of the International Law Association's Committee on the Legal Principles Relating to Climate Change. So no more from me. I shall now hand over to Christoph. Thank you.
Thank you. Thanks a lot. Thanks a lot for having me. And the introduction, of course. We work in the international climate change negotiations, but increasingly also with countries on the ground that try to implement the Paris Agreement and other rules of international law. My background is really nothing else but international environmental law. I've been doing that for the last 20 years with different hats on. As you can probably tell by now, I'm born and bred in Germany, and when we went to university and learned about public international law, it was a very dogmatic approach that I think the academics at the time in Germany had, and they looked at the rule of law very much as the UN Charter as a bit of a constitution. Then you had your laws of international customary law, jus cogens, if you believe in jus cogens. And underneath this overarching framework, there were lots of international agreements. There are even more now, and they form what is probably the rule of law in a specific area amongst the states. And if there is a conflict between these rules, then as a lawyer you're supposed to harmonize the interpretation. But then I came to the UK and I studied international law under Rosalind Higgins at the LSE. At the time you could go to different colleges. I'm not sure that's still possible. And for her, international policy and law, power, rule of law, it was all one. And as an American, it's probably quite easy to come to that conclusion. It, at the time, blew my mind. I increasingly understand it, having been in this environment for so many years. But for the purposes of this short presentation, I want to go back to what I learned at university and look at maybe the standard perception of the rule of law, how it applies between states. And when it comes to climate change, it is, of course, predominantly the UNFCCC, the UN Framework Convention on Climate Change, and now the Paris Agreement that form the body of law that states should abide by and comply with. There's also the Kyoto Protocol, but no one says so, but it's pretty much history. I think sooner or later the parties will decide to retire it or discontinue its application. We'll see. So looking at parties' compliance with the Paris Agreement. It's, of course, a very new agreement. It was adopted in 2015, entered in force in 2016. It's very much built around nationally determined contributions. All states say what they think they can contribute and achieve over a period of time. So the first provision in the Paris Agreement deals exactly with these nationally determined contributions. And Article 4 provides that these nationally determined contributions will represent the progression beyond the party's then current nationally determined contribution and reflect its highest possible ambition. And then further down in the same article it says, any party may at any time adjust its existing nationally determined contribution with a view to enhancing its level of ambition. So, what if a country suddenly decides to put in a new NDC that's actually weaker than the previous one? Or they completely change the way they determine their national contributions. They change the reference year, they change the methodology of how they calculate their contributions. Is that a case of non-compliance? Look at the paragraph. Will is certainly not shall. So there's quite a bit of flexibility for states. The agreement in various places refers to highest possible ambition. No one checks that. It's just the countries themselves that determine what they think is possible. Whether they are actually already in a situation where they could promise much more, have the technical ability to achieve much more, no one's going to check. So, and even if, and that was the case, a country then decides, well, we adjust our NDC downwards, not upwards. It just says they can do that, but with a view to enhancing its level of ambition. Now, again, is that some kind of compulsory obligation? You know, I think you can argue this either way. And if you look at the overall spirit of the agreement, the idea, of course, is that over time, contributions get more and more ambitious. But in the text, that's not really reflected in the same shape form. So the lawyers have played tricks there, and the parties, when they negotiated the whole thing. Another case, compliance, Article 9.3 says that developed country parties should continue to take the lead in mobilizing climate finance from a variety of sources, instruments, and channels. I don't know of, I mean, if you have a commercial client and you advise on a contract, I'm not sure you would use that kind of phrase because it's pretty vague. And developing countries, they have fought hard to get something more binding into the text of the agreement, but unfortunately they completely failed. So they tried to get something that is a bit more binding into the Paris Agreement, but unfortunately did not succeed. The more concrete commitments are all dealt with outside the Paris Agreement in COP decisions. So here there was already a commitment from Annex 1 or from developed country parties to raise at least $100 billion per year from 2020. No one knows how much climate change will cost the world. It's just another figure picked out of the air. There are various stories where this figure comes from. But at least it was on the table, and it was a concrete promise which the developed countries failed to meet. It became increasingly clear in the lead up to Glasgow there wasn't a clear-cut commitment of at least 100 billion US dollars. But COP decisions are not legally binding on the parties in any shape or form. So again, there is a commitment on the table, but although it was not fulfilled, the parties are now negotiating the next goal, and that's how it often goes in international law and policy. It is a focus on a certain goal. You might reach it, you might miss it, but then you're off to the next one. And I think that's probably very similar with the Sustainable Development Goals or the Millennium Goals. And the developing world here really has two major problems. One is that they need to find the right number for a financial commitment, but then also need to find a way that this is a reliable commitment that developed country parties actually meet. The last compliance case I wanted to look at is a bit of my personal fight. Article 4, paragraph 16 says that if parties have reached an agreement to act jointly under the Paris Agreement, and that's so far only the EU. The EU has a joint NDC. Then the terms of that agreement, including the emission levels allocated to each party within the relevant period of time, should also be communicated to the Secretariat. The EU has not yet been able to communicate that agreement because it doesn't exist. They are still negotiating the relative shares under the EU ETS, the emission trading scheme, and the burden sharing legislation. So as long as they don't really know who is responsible for what, they of course can't notify the Secretariat accordingly. And I brought this up with them, and the spokesperson of the Commission said the EU is in full compliance with the Paris Agreement. And that was the end of it. So you see, there are always interesting arguments one can possibly make in the and that's of course that is, you look at compliance, abidance by the rule of law. The other question then, of course, is what are the consequences? And in international law, we have the Vienna Convention on the Law of Treaties. Only serious breaches really have consequences, and most of these multilateral environmental agreements have a separate mechanism to deal with them. In case of the Paris Agreement, that's been captured in Article 15 and a set of rules on facilitating compliance and implementation. And here, the Compliance Committee, that's how the developing countries usually refer to it. Others say just Article 15 because it doesn't have any teeth. It's really just a committee, like many others under these international environmental agreements, that monitors implementation and then supports parties in meeting their commitments, offers some capacity building, some technical support if possible. And the only 4 cases where this compliance committee can actually take action is if a country does not have an NDC at all, if they have not put anything on file to say what they have promised to do in the future. And then there are other reports that they have to submit, like an inventory report on emissions. Now, if they fail to submit that, the committee can become active, and there are a few other procedural, purely procedural obligations, where the committee can follow up what parties could do if they fail to meet their own promises. In addition to all this is, of course, to self-report. And I think that would be a sign of, how important they consider the Paris Agreement provisions and the rule of law in this context. But I can tell you that's not going to happen. So I don't know if it really makes a lot of sense in these times to talk about the second dimension of the rule of law. As I would see it, one, states need to abide by their legal obligations. But then two is that they also need to create a wider enabling environment where not only state A and B, but everyone can meet the same kind of basic standards, and people all over the world can live with certain human rights, for instance, guaranteed. And that was one of the issues in the negotiations leading up to the climate agreement, that human rights could have been acknowledged, in a universal context. Climate change threatens human rights all over the world, but usually states are only responsible if they happen, these violations, under their jurisdiction. So there were lots of civil society organizations that campaigned to give them a wider remit, but it simply did not happen. But there would have been an opportunity to, I think, create those wider enabling conditions and really extend the rule of law into a proper multilateral system. And that is under threat at the moment. That's why I'm a bit hesitant to promote it any further, but I don't think we should yet give up on it. If you are interested in looking all this in a little more detail, we have a little app that contains the text of the Paris Agreement, but also further explanations. So you could just scan this in if you're interested. Thank you.
Thank you very much, Christoph. That was wonderful and really clear, and tells us about the rule of law as well, so thank you. We're going to move on now to Mikhail Robertson. Mikhail is advisor to the Alliance of Small Island States, and he works at the Department of Environment of Antigua and Barbuda. And perhaps most importantly, Mikhail is a graduate of UCL. We never ever do let you go, honestly. So I hope you're there, Mikhail.
Thanks a lot for the introduction, and thanks a lot to Christoph for that really good presentation on the rule of law and the Paris Agreement. So my task here is quite simple. It's to look at the rule of law, but some key outcomes coming out of COP26. And just to note as well, I do have to put a disclaimer that the presentation that I'm making here is in my personal capacity, as opposed to representing the views and opinions of the IOSIS or the government of Antigua and Barbuda. So let me just go quickly into it and look at the overviews of what I'm going to discuss quite quickly is the rule of law in international law. Then thinking about the international climate change regime, I know Christoph did start to discuss that in some length, as well as its quote unquote legislature. Then the third part would focus on lawmaking under a COP, and I put lawmaking also in quotes, especially given the discussions that Christoph just had as well on the difference in opinions on lawmaking under MEAs. But a theoretical framing of it using a very near and dear paper that actually I first was introduced to at UCL. Then after that, we have the fourth section going into the meat of the matter, which is COP26. And I would look at tracking the rule of law similarly to the goal that Christoph was talking about for climate finance, but looking at it through a slightly different lens, and then looking at how we potentially form the basis of the rule of law under the Paris Agreement, noting that that first goal was focused on the convention. So let me go quickly into it. So the first thing is I started with a definition of rule of law that I did look at the Oxford legal dictionary, looking at it, and it focused on rules, rule-based legal order. And I think the most important thing was as well is the normative force that these laws have on its intended audience as well as their behavior. And I think that's quite interesting to look at that from the rule of law lens, of how the law is used as a tool to sort of change behavior from that certain aspect and lens. And I think the next thing to look at as well from a more formalistic perspective is obviously the Vienna Convention on the Law of Treaties. And looking at it from a very rigid sort of discussion on, as most of us are lawyers in this room, on consent to be bound and consent to be bound by states, but as well the different vehicles in which consent to be bound can be expressed. Noting that there is in Article 11 that focus not only on signature, exchange of instruments, ratification, but also by any other means so agreed, which is very interesting in the context of the UNFCCC and the COP. So let me just quickly, though, give you a general introduction. And I did listen to some of the other presentations before us that gave you an understanding of what the COP is, which is where the state parties meet together annually, not only for the convention, but as well for the protocol, the Kyoto Protocol, as well as the Paris Agreement. So just quickly on its role, which is also stated before, it's the supreme body as it respects to the treaty. And this is where we come and have a clear understanding of and sort of discuss the decisions that are necessary to promote the effective implementation of all of these treaties in their different respects, noting that they're different treaties. And after that, what is clear is that the decision-making process, which is a bit unique in our circumstance, but there are other MEAs that do have this process, is that it's by consensus. And the reason being is that the rules of procedure, the section that dealt with decision-making, which had various different options for voting, was not agreed to due to lack of consensus. And so what has now happened in practice is that we apply the draft rules of procedure, except for that section that deals with decision-making. And what we do is decision-making by consensus. So that's also important to understand from a legitimacy perspective, sovereignty, and all of those different matters that we kind of link as it relates to consent to be bound and sort of normal legal law making, right? So the next thing that I'll look at is the theoretical framework that we're kind of focusing on. And so I used a paper by Jutta Brunei, he's a well-known legal scholar and academic currently based at the University of Toronto. And it does recognize that there are certain decisions, COP decisions, and that as law, that they have a certain degree or of normative force and influence over states. And so when looking at that, the presentation that I'd have and look at would seek to understand the extent that some of these laws, quote unquote, rule, to keep within the theme of the presentation, as well as how some of these laws are formed prior to their rule. And as I said, I would use some examples from COP26. So just to give you a more pictorial understanding, I like pictures and graphs. They help to sort of solidify things a bit more for me. We heard a lot from the formal perspective on sort of lawmaking under MEAs. And note that this is taken from the concept is based on the writings of Brunei. And so the focus on consent to be bound is one way of looking at it. But however, there's another school of thought on interactional perspectives. And so that focuses on the interaction between the states underneath the actual multilateral environmental agreement and how it shapes norms and influences behaviors. So I think that is a crucial thing for us to keep in the back of our head as I present some of these examples and how it sort of forms and influences our behavior as states, the main actors for these treaties. So I'm sure many persons in the room may know this man. So this is the former UK Prime Minister, Gordon Brown. So this is him speaking at COP 15 in Copenhagen. And the reason I have him up is because when you go to my next slide, he was quite instrumental in, and I'm happy Christoph mentioned that, it was quite a random number of 100 billion per year and mobilization number. And I think that we should just kind of keep that framing in mind as we discuss the tracking of the rule. But to give you more context, where it essentially came from is actually coming out of the Bali COP that looked at long-term cooperative action and trying to ensure that we basically operationalize the relevant law that we're looking at. So the relevant law on support and providing support for implementation is based in Article 4 of the convention itself. And so developed countries, and it provides it, and this is just a summary of it, of the commitment, is that they shall provide new and additional finance needed by developed countries to meet the incremental cost of mitigation as well as adaptation. And so after we had that sort of contextualization in the convention itself, we looked at then the sort of tasking of the Bali Action Plan to go ahead and figure out and try and get this agreement sorted out in Copenhagen. What came out was this looking at a commitment to mobilize, jointly mobilize as developed countries, 100 billion per year to address the needs of developing countries. So you can kind of see that this is squarely rooted in its sort of legal origin in Article 4 of the UNFCCC. So as we look at, and then we have the relevant law, what we did in COP26, as Christoph was talking about, was that there was a clear deadline by 2020. And so COP26 became this sort of venue for discussing the progress of the goal. And there was a lot of fanfare around that and seeing whether or not they achieved the goal. And so what I would do in this next slide is show you, this is actually from an OECD report, the trajectory over the years as they sort of tracked climate finance and somewhat the small but incremental growth of climate finance that was coming from developed countries to developing countries being provided and mobilized. And so I'm changing you to another report that was done by Oxfam, which shows you slightly less amount of climate finance being provided. But however, it's increasing over time as well, slowly but surely. And the reason why I showed you those two different graphs is because there was an issue, as Christoph was saying, that this goal was just randomly committed to. So the issue with tracking and monitoring and ensuring compliance with it, they didn't have those mechanisms attached to this commitment. So it's just a commitment without the adequate mechanisms behind of it to sort of follow and track and ensure that there is a centralized understanding of even the basic question of what is climate finance. And so just to give you that sort of crash course in climate finance and the goal and the mobilization, well, let's bring it back to the rule of law now. Let's bring it back to the outcomes, right? And so I want to kind of summarize some of the normative and political sort of what that pressure potentially pushed developed countries in relation to them achieving the goal. And so the first thing is that there was increases, even though it's, as I note and have a high caveat, extreme caveat on it, is that the monitoring process, there hasn't been one that was adopted multilaterally by the COP itself. And so this is something that we're looking at in the new goal context. The next thing is the establishment and the capitalization of what is the world's biggest multilateral climate fund, which is the Green Climate Fund. And in that same, in the Cancun decision, which came after the Copenhagen decision, you could clearly see that there was a substantial push to try and put all multilateral finance through this fund. And so with that goal as the background, you see countries now putting more funding into this process in line with using the goal as a backdrop, as a context. The next thing that comes out of the sort of political pressure on this was as well in Paris, that there was the creation of obligation on the CMA to set a new collective quantified goal, which Christophe talked about, as well as what we decided on in Glasgow, which was the process for the deliberation, which was now inclusive of all developing countries, all parties around. And we actually had our first technical expert dialogue in South Africa, which I was a participant in, as we tried to create a more robust process for a goal that's very important to all of that ambition that Christophe was talking about, and in the Paris Agreement. The next thing is there was also acknowledgement of the clear failure of meeting the commitment. So technically, in a rigid sense, the rule of law, there wasn't really, the ruling of that law, if you want to consider that to be law in that specific sense, from a more formalistic sense, but from an interactional perspective, as Brunei is proposing, you see some normative political behavior changes, but however, we need a lot more to be done. And then the last thing is there was a lot of pressure for developed countries seeing that they failed it, and that now they have a requirement to push forward with continue to achieve the goal until we set a new goal in 2025. They had to provide us with a delivery plan, which needs a bit more work, but we're trying to push developed countries to have more teeth on how exactly they're going to achieve the goal through to 2025 before we have the new goal. So Maria, I guess on time, I know that I'm not sure how much time I have left.
You've got 2 or 3 minutes. You've plenty of time.
Okay, great. And so just in summary, there are two other things that I want to focus on, which is both markets as well as transparency. So this is just a picture. I do like pictures to break up all the text and all the chatter. And this kind of captures the US here with John Kerry. You have the Russian special envoy, as well as in the corner on the right, the EU's Vice President Timmermans. They're having some discussions on the final day, which then focus on establishing and forming a key basis of the rule of law for a specific area, specific thematic area, which is the market mechanisms. And so the relevant law was that we as the CMA had to adopt rules and modalities and procedures. And this was clearly outlined in the Paris Agreement. So you have this specific mention in a treaty that tasks the CMA, so the COP for the Paris Agreement, to adopt these rules, which will then have legally binding implications on whoever would like to interact, as in whoever being parties that would like to interact with the market mechanism, the sort of trading of these activities. And so what we had was that we adopted the rules in Glasgow, and that now looking at the potential outcome of it and the rule of law based from these rules, modalities, and procedures, is that we will have effective use of this mechanism in line with the established rules. And I just want to highlight two things: is that firstly, that there needs to be an allowance for higher ambition, in addition to what Christophe was saying, but as well to promote environmental integrity. As looking at the somewhat of the failures of the clean development mechanism under the Kyoto Protocol. So it should be noted that it has to contribute to mitigation, but it also has to support sustainable development. And this is done through voluntary cooperation in the NDC implementation under those rules. So it's quite crucial to understand that there is the rule of this law that we adopted in Glasgow. And I think that's the end of my time, right? That's the bell. Yeah, okay, no problem. And so just to let you know that this is again another picture. I was going to talk about transparency, which had a similar sort of discussion on the rule of law from this perspective of us adopting the tables as well as adopting reporting formats that again now become standards for our reporting timelines and formats as we track progress of achieving the goals of the Paris Agreement. So I'll end there, Maria, and thanks a lot, colleagues.
Thank you, Mikhail. That was fantastic and a really wonderful way to look at this question of finance through this rule of law lens. I really enjoyed that. Thank you. And nice to see the links between your paper and Christoph's paper as well. So with that, we will move on to, in fact, our final paper of the day and of the conference. Julio Cordano is a diplomat serving in the Chilean mission to the UN, and he is former head of climate change and sustainable development in the Chilean Ministry of Foreign Affairs. So I will hand over to you, Julio.
Thank you very much, Maria, for that introduction, and thank you for the invitation to be part of this panel. And I'm really glad that my own presentation will touch upon a number of issues that were already covered by the previous speakers. But I have the feeling that we will be sort of touching the same topic from different perspectives. So I hope that it's going to be complementary among them. So I hope, can you see my screen now?
Yeah, that's great.
Great. So I'm put it in presentation mode. So there you go. So thank you again for this. And I'm going, I'll try to do is to make a few remarks about also the connections between the formal or official way of making decisions under UNFCCC, and maybe equate that to the traditional law. Or how parties get to agreements that are durable and binding. And in my presentation, this is the Paris Agreement, the Convention, but also the decisions. And I know for many the decisions are not legally binding per se, but I think from Mikhail's presentation, I think it's very clear that as in this 25 or 26 years of implementation of the convention, you see a coherent building up of different rules and different schemes and arrangements that have been coherent in the way parties understand how to tackle climate change at the global level. But at the same time, it is very clear that outside of those formal agreements and those papers that are coming out from COPs every day, every week, every year, you have a number of discussions and initiatives that are happening outside of the COP that influence the outcomes that parties agree in every conference. So what I'm going to do is to explain in my own view why is soft law important in climate multilateralism. I will put one example that is very close to our own experience as a party to the convention, which is the ocean and how the ocean got its place into the COP. I will also argue that the ocean is not an isolated example. It's actually part of a trend, and I will show some examples, especially if coming from COP26, but by far is not the only COP that has had specific initiatives on this. And I will also offer some final thoughts on how this trend might evolve and what are some of the frontiers and elements and topics that could be brought into the attention of the COPs from informal spaces for the consideration and possibly adoption of new agreements in the COP. So that's the plan of the presentation, and I hope I will stay within the time allocated. So first, why is soft law important in climate multilateralism? So the main point here is that, as I think it was said in the previous presentations, it is very clear that the Paris Agreement and the Convention have their own shortcomings and weaknesses. It is clear that the Paris Agreement set a very clear understanding of where we want to get in terms of long-term goals, and in Article 2 of the Paris Agreement that is extremely clear, but at the same time, it does not provide per se the necessary tools and mechanisms to achieve those goals. And I think Mikhail was already making reference to the transparency framework and markets and finance, which are all absolutely needed elements in the structure of the Paris Agreement. And yet we've been negotiating for years and years about how to implement those and how to make sure that we have those mechanisms in place. So the Paris Agreement specifically does not cover the full range of initiatives and actions that are needed to achieve their own goals. This is also important. It is also important to mention that the Paris Agreement does not go into arrangements or specific commitments from parties in a legally binding way, as it was in the Kyoto Protocol. That model was somehow overcome by the Paris Agreement, but also it does not go into aggregate agreements for specific sectors of the economy where emissions are happening. For example, there's no discussion around energy, for example, and the Paris Agreement does not go specifically into the different sectors that are relevant for mitigation. So there are those shortcomings, and for example, the conventions aims at the stabilization of the greenhouse gases in the atmosphere, but of course falls short of providing specific provisions to achieve that. And the same thing happens with the Paris Agreement, as I was just explaining. And therefore, it is very important that what is happening in the margins of the COP in terms of informal consultations, informal discussions, partial agreements, declarations, outside pressure from the civil society, in order to understand where are the priorities and what is politically feasible in terms of making good progress in the implementation of the long-term goals of the Paris Agreement. This is why soft law is so important in climate multilateralism. It's like a force that is pushing us to cover those gaps, normative gaps and implementation gaps for achieving those goals. And one example of this is the ocean, and this is of course something that is very close to our hearts and in the Chilean delegation, as you all know, and the IPCC and the science in general has proven very clearly that the climate system and the ocean are part of one single system, and there's no way of understanding one without taking the other into consideration. Both of them are profoundly affect each other, and therefore they need to be taken in one single shot in terms of understanding the global problem and of course in providing solutions. And yet, and even if the ocean is already mentioned in the convention in 1992, it was only in COP25 under the Chilean presidency that was officially recognized. So it was brought into the decision acquis, if you want, only in COP25, 25 years after the first implementation or the first COP of the UNFCCC. And it was interesting to see that the road to that recognition, or the road to that official entering of the ocean in the negotiations, was through precisely a number of instruments that could be understood as soft law, like, for example, the 3 Because the Ocean declarations that Chile and many other countries supported in COPs 21, 22, and 26, but also important progress in discussions like the Ocean Pathways. That was an initiative that the Fijian presidency brought to the attention of parties in COP23, and very relevant, the findings of the IPCC special report on the ocean and the cryosphere that prove with very hard facts how important the ocean is for the global response to climate change. And in COP26, all this force, all this energy was catalyzed in COP26 with the agreement of a permanent dialogue on ocean and climate, that the first one will happen in Bonn in a couple of months. I will also need to say that COP25 recognized the ocean and mandated the first ocean climate dialogue that happened virtually due to the pandemic in December of 2021 or 2020. So so that's one example. I don't want to stop for too much on this, but I want to move on to stay within the limit of my time. So the example of the ocean, as I was saying, is not an isolated example, and it's actually part of a trend. It's a long trend. It's not something that started in COP26, but COP26 offered good examples of what the future could look like in terms of informal discussions and soft law that could result later on in formalized agreements. The US and China declaration that was struck and published during COP26 is a good example. As you may remember, the US and China have had declarations in the past. Some of them have made easier to achieve the Paris Agreement itself. And some other agreements that have been able to do, since they are the major emitters in absolute terms in the world. But also important declarations were also presented in COP26, like the declaration around methane, that maybe it's a forgotten a gas. We all talk about CO2, but we forget that we also talk about CO2 equivalent, and the equivalency is with methane is particularly important due to its contribution as a potent greenhouse gas that needs probably specific regulations and specific agreements. So that's and that declaration was supported by more than 100 countries. So that's an indication that there is willingness to discuss further about this, and the question is what type of agreements we can have at the COP level. Same thing would happen with forests. Forest is a very old topic in the COPs, but somehow we haven't been able to find mechanisms that are effective to combat deforestation. And in many parts of the world, including Latin America, deforestation is one of the major sources of emissions. So it's extremely important that we have a discussion around that. The synthesis report on the aggregate effect of the NDCs by the UNFCCC Secretariat was also extremely influential, and the outcomes that came from that report clearly set the tone of what we all need to understand as the needed ambition. And I think that created an influence, a very important influence in the outcome of COP26. It's not it's a report of the Secretariat. It's not a binding document. The outcomes are not binding, and yet the solidity of the information that was behind it was clearly influential in this. Other initiatives like the Beyond Oil and Gas Alliance is shaping up as something that could create a space for discussion around exploration and exploitation of fossil fuels. And it's a question mark whether we will be able to advance that discussion into something that will influence the outcomes of the COP. G20, of course, has a very important role in fossil fuel subsidies and also coal phasing out. And we saw the last night in Glasgow how difficult that discussion was, but at the same time, the G20 is a space where probably we will look for leadership in this kind of agreements, and hopefully COP26, the COP26 language around this will be the basis for more outcomes in COP27. And finally, I just put the IPCC assessment report, the sixth cycle of the IPCC, as an extremely influential information that parties are responsible of. Let's not forget that IPCC is not a scientific research group. The IPCC is an intergovernmental panel on climate change, and therefore the summary reports are negotiated and adopted by parties, and somehow is not policy prescriptive, but at the same time is evidence that the parties understand collectively as true, and therefore it creates a lot of pressure for acting upon it. So the ocean is not an isolated example, and as I was explaining, and let me just go for the last point of my presentation, which is around what the future could look like in these circumstances. Of course, as much as we see good examples and success stories around informal agreements outside of the COP, the consensus-based progress will continue and is needed. Even if the Paris Agreement has its own weaknesses and shortcomings, we will need the Paris Agreement as our sort of mothership to report to and to take action on it and use it as our main chart for the future. And at the same time, we will need to take it with a pinch of salt. I mean, we will have to adjust to keep up with the international pressure to close the ambition gaps. And we cannot just ignore those shortcomings, and we need to work around it to cover those gaps. And it is very important. This is our own experience also as a presidency of COP25, that we cannot ignore that there's going to be an increasing pressure from outside of parties and governments as climate change effects worsen and the pressure for concrete outcomes increases. If the evidence of climate change happening, creating many adverse effects will be an extremely powerful tool to put pressure on parties and to aim for something much more ambitious and to close the ambition gaps of the Paris Agreement. And this in this dynamic, there is a question that at least I can make to my own conscience. Should we openly recognize and use soft law as the back engine to achieve formal consensus? Since we understand that there are these gaps and these shortcomings, should we sort of create spaces for parties to openly, debate and have open initiatives and invitations to explore without the pressure of achieving consensus, to explore possible solutions to move forward? I think there is a spontaneous movement towards that direction, but at the same time, it would be interesting to discuss it more, whether the COP offers that space, whether we are maybe spending too much time in the negotiation room, maybe going over agenda items that don't go anywhere, and maybe save that space for going to the most urgent issues. And my final slide is about some potential new territories or developments or topics that might be brought to the attention of the COP. And I'm probably sure I'm probably very close to the end of my time allocated, but let me go through this very quickly. So the discussion around mitigation ambition on NDCs, the COP25 presidency promoted the Climate Ambition Coalition that was 120 plus countries that committed to carbon neutrality by 2050, and that was a very important step towards understanding that there's a majority of political willingness around this, and probably that allowed and paved the way for further agreements. There is a huge gap in adaptation, and we very much look forward to the discussions on the Glasgow Sharm el-Sheikh work program on the global goal on adaptation, but there is a huge question mark around how to increase resilience and adaptive capacity based in international solidarity. That's a discussion that has just started, and probably we will need much more initiatives and informal discussions on that. Same thing applies to loss and damage. We don't have strong arrangements to address loss and damage, and probably we will need to look into that more closely. I think there was mention about human rights. The preamble of the Paris Agreement mentions for the first time human rights it's there, but at the same time nobody really knows how to achieve agreements on how connect the obligations of parties on the human rights commitment, while at the same time considering those obligations in the context of implementation of the climate policies. There is huge elephant in the room around technological solutions for mitigation that has not been addressed at all in the COPs, and yet there is an increasing noise around carbon direct air carbon capture and storage, and even worse, solar radiation modification, which is something that should concern us all. There is another important issue about the private sector and the accountability they have in terms of their own commitments for mitigation of gases. Should the COP look into it? There have been some attempts to do that. There are many complexities, but only yesterday the Secretary General of the United Nations started a task force to look into transparency of the private sector commitment. So it is a very relevant topic, and we don't know how to deal with it at the COP level. And finally, on carbon pricing, there's many discussions around climate clubs with implicit penalties for non-participants. Would that be something that that could be discussed in the margins of the COP in order to increase the pace of implementation of the Paris Agreement? These are all open questions, and I hope I have been able to spark your imagination and curiosity around these topics, but definitely shows how many flanks are open in the climate discussions, and how much do we need these spaces for informal discussion and the soft law to precisely put pressure on us to achieve a more ambitious outcome, and hopefully agreements in the context of the COP that are transparent and equal to the need that we have to implement the Paris Agreement. So I think that's my last, slide. So thank you very much again for the time and for the opportunity to present some of the ideas. Thank you.
That was wonderful. Thank you so much. This idea that we've got, the power of knowledge, the power of information, the power of people coming together and creating pressure, I think is an absolutely fascinating way of looking at this. And isn't it interesting that we've got to the final panel before we've had an explicit title including soft law? I suspect that's quite unusual for a rule of law conference, and it might say something about climate change and the way we're thinking about it. Okay, so I'm going to wrap up very, very briefly, but first, shall we thank the speakers on this panel? That was fabulous. Thank you very much. So I'm wrapping up. I'll be very quick, but I'm wrapping up on behalf of our large organising committee. So there have been 6 of us: Eloise Scottford, Stephen Vaughan, myself, and Monse Madariaga, Sonam Gordon, and Jonathan Church, who we've all met. And we're not going to do little thank yous separately, but I think a big mutual thank you to the 6 of us. It's been a long process, and here we are. We've enjoyed it overall, I think. Okay, so I think, what have we learned? We've learned that this is a really important theme, and that we don't yet really know what we're doing with it. That actually we've got a lot of work to do on this idea of rule of law and climate change, because it matters, but we have no answers. I'm going to just pick out a handful of themes and try and bring us back to the rule of law. First thing I'll say is that we've had a lot of elephants in the room over the last 2 days. That phrase has been used a lot. And what that says to me is that there's a lot going unspoken in this debate. And I think that's pretty clear, that there are so many different perspectives, and it's such a big issue, huge, all-embracing. The other thing that we have to think about is the complexity of both climate change and rule of law. And they are both not just complex in the way you'd expect, legally and jurisprudentially for rule of law, physically for climate change, that they're both whole society, whole legal system, whole economy challenges that we're going to struggle to work through. And we've had lots of really thought-provoking interventions over the last few days. The other theme that I think has really come up a lot is vulnerabilities, and the difficulties of thinking through in any sophisticated or subtle way who wins and who loses. It isn't always quite as obvious as it looks. So that's another theme that I think has come up a lot. And if we go back to rule of law, there's a question about how much rule of law helps overcome those vulnerabilities and how much rule of law might be complicit in intensifying some of those vulnerabilities. So it's an important conversation. And the other theme that's come up right from the beginning and again today is whether the rule of law inhibits or enables collective action. And, you know, climate change requires collective action, so that's something we have to think really hard about, even if we might be a little bit resistant to the way the individualistic approach to rule of law is expressed or finds itself working. The other thing that's come up such a lot is the question of institutions, and I liked the way a couple of people yesterday referred to this as ideas of social assets, social achievements, as much as institutions. These precious institutions and social achievements need to be treated with care, and they are subject to both neglect and malice. And we don't get far on climate change if we lose these precious institutions. Climate change will also attack these precious institutions. And I think that brings me back to something that's come up implicitly a lot, but which Stephen mentioned in his presentation yesterday, which is this idea of thoughtfulness, and that rule of law asks for reasoned thoughtfulness. And I suppose so does climate change, so does the complexity we've been thinking about. So now, on behalf of the whole organising committee, I've got some thank yous. So first of all, thank you so much to our speakers. We've had some wonderful, wonderful papers over the past 2 days. Thank you to our chairs. Thank you also to all of our mentors. We think it's quite important to bring the early career researchers into our community, and the mentoring role is crucial, I think. And thank you, of course, to the audience, online and in person. Perhaps for the online audience, we've looked like we've been having such a good time that they're going to get themselves out to a conference soon. I hope you're able to. It's been rather wonderful. And on this, I think it's worth saying that this hybrid conferencing is complex, really very, very complex. Now, organising any sort of conference, you know, everybody here knows it's a lot of work, and that's fine. It's a lot of work. It's supposed to be. But the way this has worked has been a really complex job. I think it has worked, and I think we shouldn't be embarrassed by the fact that we've had one or two little occasions where things have fallen over a little bit, because this is all new to us, and it has to be crucial if we're going to keep doing global conferencing without flying around the world at the drop of a hat. So we're taking the very first steps in learning how to do this and learning how to get it right. And we will, I suppose, as we get even better at this, we'll improve the conferencing experience for the people who aren't here in London. So we'll try and get that bit a bit better. But it has been extraordinarily complex. And even though we've had this massive organising committee, we have created an awful lot of work and stress for our colleagues who have made it happen. So of course we have Kat Balogun, who has, as always, taken the trouble off our shoulders and made the conference work. And this time we've also had our educational media people who have been extraordinary. My mind is blown by what they've managed to do over the last couple of days, but that's Teresa and Diana. Thank you very much to all of you. We are all grateful.